The scariest part of a custody battle isn't the paperwork. It's knowing the judge may never truly understand your child's reality behind closed doors. When you're co-parenting with an abusive or controlling ex, the stakes couldn't be higher because you're not just fighting for yourself, you are fighting for your child's safety, their voice, and their future. And that's exactly why we're here today. Hi, friends. I'm Tiffany Lesnik, domestic violence attorney, survivor, and founder of Live Free Legal, where we help women break free from abusive marriages and fight back with strategy, confidence, and God-given strength. And today I'm honored to be joined by someone who has shaped the national conversation on how children are represented in custody cases, Suzanne Chester. She is the former director of the Child's Advocate with Legal Aid of North Carolina. She is a national trainer and a trauma-informed child advocate and author of the widely read article, Reunification, Alienation, and Retraumatization. Let's start listening to the child. She is also the owner of Child's Voice Law and is championing children's voices and promoting their best interests in family law matters. Suzanne has trained hundreds of lawyers and therapists across the country and is one of the leading voices challenging outdated approaches to child representation. Here's what we're diving into today: how judges really hear children in custody cases and how often things can get lost in translation. We're going to talk about GALs and guardian-led Litems, what they actually do and how to work with one, the differences between reunification, alienation, estrangement, and re-traumatization, and how to recognize when therapy is helpful and when it's not, and when child-directed representation, or what child-directed representation is, and how that's changing the landscape of child advocacy. And then finally, how mothers can advocate for their children without being labeled uncooperative or alienating. And of course, we're answering your live questions throughout the broadcast. This is one of the most important conversations we'll have all year, especially during Family Court Awareness Month, where we shine a light on the children whose voices are too often ignored or misunderstood. So please drop your questions in the comments, say hello in the chat, and let us know where you're watching from, because your child deserves to be heard, believed, and safe. So let's get started. Suzanne, thank you so much for being here. Thank you for all that you do to represent the voices of children. Would you tell us a little bit about yourself?
Thank you so much, Tiffany. It's a real honor to be here with you and to be talking to this group of survivors. In the 30 years I've been practicing as an attorney, a lot of it was spent at Legal Aid representing victims of domestic violence in protection orders, in child custody matters. Then about the last 10 years of my career, I began directing the Child's Advocate, which, as Tiffany said, was at Legal Aid of North Carolina. And that was a really interesting and, I believe, wonderful program where the court would appoint an attorney to provide direct representation to the child. And what that means is that just like you have an attorney who advocates for what you want, we as attorneys for the child would advocate for what the child wanted. But, you know, like every good attorney-client relationship, we would spend a lot of time counseling the child and kind of explaining to them what was going on, because as I'm sure you know, many of your children may be quite confused. I have two grown daughters of my own, of our own. My husband and I live here in Raleigh, but we have two grown daughters. And I have been passionate about children's representation, specifically in family court, since I really got focused on this about 12 years ago, I guess. Before, I had a strong interest in it, but I was usually representing the parent, oftentimes the mother, in domestic violence proceedings. And so now I have my own small firm, and I'm really trying to make the guardian ad litem role a really child-focused one.
Yes. And I do want to definitely talk about that. So you have your own firm now. Tell us the name of your firm and what you're doing with your firm.
Sure. The name of my firm is Child's Voice Law, and my focus is on court-appointed guardian ad litem work. I will be doing parenting coordination work beginning in January of next year. I also do domestic violence work, and I'm particularly interested in representing children when they're the ones who have to actually be named in the case. But I also represent survivors of domestic violence. And let me see, what else do? I do a lot of consulting. I consult with, sometimes it's parents who are in the middle of their own custody litigation and they want to consult on a specific issue. I love to train attorneys. I've trained attorneys in Maryland and other places on how to represent children, how to implement that direct model of representation. And over the years, I trained a lot of people, attorneys, and worked with judges and social workers and psychologists to train attorneys on how to represent victims of domestic violence and also how to represent children in these child custody proceedings.
Awesome. Thank you so much for all the work that you do, Suzanne. And hello, Melanie. We do have a question already. So Melanie asked, she has a question, advice for a mom who does not attend parenting exchanges. Her 11-year-old son goes to the exchange, but hides on the floor in the back seat and refuses to get out of the car. How can mom advocate for her son? So I can either help address that, or if you have any ideas, Suzanne.
If you want to start, Tiffany, and then I can add in if I have any other additional ideas on that.
Okay. So I guess I need some clarification on that question because Melanie, you say you don't attend the exchanges, but he's hiding on the floor in the back seat and refuses to get out of the car. So I'm a little bit, if you could give us a little bit more information about that, I think that would help me. But what I generally recommend in cases where children are refusing to exchange during a custodial exchange is I try to encourage moms not to get in the middle, right? We want children to become advocates for themselves. That is very important. If you are in a state that allows you to record without the other party's consent, so there are 2-party consent states and 1-party consent state. If you are in a 1-party consent state, you can record the exchange. So whether that's audio or videotape recording, I encourage moms to record what is actually occurring, so that the court can see that this child is cowered in the backseat of this car. This child is crying. This child is screaming, I don't want to go. This child of their own volition is refusing to exchange with the other parent, that you are not doing anything to intentionally interfere with that process, right? You're documenting, you're creating that evidence for that. The other thing I would say is we always want to try to be encouraging for our children. So they are looking to us, right? They are looking to us as the safe parent. They need to see that we are calm, right? That we are not panicking. If they see us in a state of panic or anxiety, they're going to feed off of that. And then they're going to be extra afraid, extra anxious. So even if we are afraid, even if we are scared for their safety, we have to put on this polished appearance that it's going to be okay, right? You are safe. We do need to have conversations about safety with our kids and have a plan in place. Make sure they have access to a phone or a watch or something, and let them know they can run to the neighbor, or there are things they can do to protect themselves. But we can't be falling apart in front of our kids like during the exchanges, because then that increases their fear and their anxiety. So putting on the appearance of, mom's got this, it really does help them. I don't know if you have anything to add to that, Suzanne.
They're great. I think they're great suggestions, Tiffany. I agree with all of them. I guess I would add one, and I would suggest, Melanie, that you speak with your child's pediatrician and ask for a recommendation for a therapist a child therapist that you could bring your child to. I think in these cases, it's really important that you, as the mother, is not the only person who can speak to this issue, because oftentimes protective parents are regarded with skepticism in court. And so you want to have a professional, and a neutral professional who would be a child therapist, who may be an advocate for your child, but they could bring a lot of comfort to your child, so the child could actually speak with somebody about what's happening and may be able to either reassure them, or if there are indications of abuse or neglect, the therapist would be the one to take it into their hands to make a report.
Yeah. And we have a couple, hi, Brianne, we have a couple more questions, but I do want to ask Suzanne, why does representing the voices of children matter so much to you?
So I've worked in family court for about 25 to 30 years. And what I have been struck by is it's really all about the parents and much less about the children. And unfortunately, when parents raise concerns about abuse or neglect, then the focus tends to go on the parent as to why they're doing this. And are they crazy? Are they coaching? I believe that if the child's voice really gets heard in court, then the judge will learn a whole lot more about what the child's actual experience has been and what the child's concerns are, what their wishes are. And it kind of takes both parents out of the equation to some extent and allows that child's perspective to be presented to the judge. And of course, the model of representation that we practiced at the Child Advocate was not to bring the child in to talk to the judge or to testify in court, but to have a relationship with the attorney where the attorney got to understand the child's experiences, their perspective, what they wanted to see happen, and could actually present that in court without actually making the child come in and testify. That would happen on very rare occasions.
Right. And we're definitely going to dive into that a little bit. But Brianne asked, and this was a question that I had too, at what age are children's wishes or children's desires for the custodial parent that they're going to live with? At what age is that taken into account?
It really varies by state. I know in North Carolina, children above the age of 8 are generally considered to have their wishes should be considered, but there is no hard and fast age. I think the older you get, definitely judges tend to consider the wishes of an older child a whole lot more. But there's, very good reasons for why much younger children should have their concerns and their wishes and their experiences really factored in very heavily into custody decisions.
Yeah. Is it your experience in all your years of litigating that younger children's desires or needs tend to be dismissed more so than older children?
I think it's harder to put on the evidence in court so that the judge actually understands what what a young child's perspective and wishes are. So to that extent, I think, yes, it's harder to present that evidence in court. And anytime I have actually brought a child to talk with the judge in chambers, it typically has been a judge above the age of 11. So with younger children, I have never done that, but I know some states are a lot more open to hearing from children, or some judges are. I think it really depends on the judge. A lot of judges are not, though, when they don't feel comfortable talking to children, or they're not trained how to talk to children, and that can be very difficult.
So I'm going to go off the script a little bit, just because I think that our audience is probably going to be really curious about this. So when we're talking about younger children in particular, so children, let's say elementary age or even younger, maybe preschool age, who are some people, who are some folks that we can have involved in our child's life that can make a positive difference in the outcome of a custody case for that child?
That's a great question, and it's a challenging question, but I think there are definitely some specific people that can be very helpful. I think having a school, if as a parent you know that your child has spoken with a school counselor on maybe multiple occasions, I think you may want to have that school counselor come to court. Now, ideally, you want to be able to speak with the school counselor ahead of time, because you never want to put on a witness unless you have some sense of what they're going to say. And you are going to need to, fight some battles with actually getting the school counselor subpoenaed and appearing in court, but it may be well worth it. I think if your child has seen a therapist, it's going to be, you really have to weigh whether or not having the therapist come to court and testify is going to do more harm than it will do good. My view when I was at the Child's Advocate, and it still really is my view, is that if there is abuse or significant neglect occurring to the child, if the therapist is the one person who actually can get this to the judge's attention through their testimony, then I think it's very important to have that person come. Obviously, it's something you would need to discuss with your own attorney before, if you have an attorney, before you actually did that. But in my experience, therapists are a fount of very valuable information. Other people, I think, if your child is participating in some type of team sport and has a coach, or an individual sport like gymnastics, has a coach that they're close to, it may be worthwhile considering that person as a potential witness. It may not be that they have witnessed, any kind of abuse or neglect, but they may be aware that, the child may have more difficulty getting to the extracurricular sport during the weeks when the other parent has them, or the other parent is refusing to take them. Different things like that, which definitely go to the best interests of the child.
Right. Yeah. And I do encourage, I encourage my, my coaching clients and my clients in general, look around, like see who is surrounding your child. Is it a teacher? Is it a therapist? Is it a Sunday school teacher? Is it a neighbor? Is it their best friend's mother? Who is around your child that can come in and testify? We a lot of times forget that testimony is evidence. Right? Someone else's word is evidence. We don't always have to have photos or records. That's evidence too, but someone else's eyewitness of what has occurred. And it doesn't have to be that they saw the child being abused, right? It can be that they saw this child falling apart. They saw this child being dysregulated, or coming back from dad's house, crying, unable to get themselves together, whatever. What does this child look like when they get back from an abusive parent's house? So they can testify to those kind of things. Be paying attention, be mindful of the people who are around you, the people that are interacting with your child. And certainly there are records, right? So you can get school records, you can get therapeutic records, you can get medical records, you can request all of those records as well. When you talk about having a therapist come to testify, we want to make sure that we don't do harm by having them testify. Can you elaborate a little bit more on that?
So sometimes, and I know this is a concern with some judges, that when a child's therapist is brought into the legal proceedings, it's going to lead to, well, one, a breach of confidentiality, because the therapist is going to be testifying to confidential discussions that they've had with your child, and that it also could lead to an ultimate breach in the relationship. If the other parent has shared legal decision-making authority, they may not allow the child to see that therapist in the future. What's really important, I think, in court is to ask the judge for a provision in your custody order saying that the child can't be removed from a given therapist who's testified in court, so as to protect that child from having, or the therapist from having, repercussions as a result of having come to court. One point you made, Tiffany, that I think is really important, neighbors and friends, but certainly neighbors, can be incredibly strong, powerful witnesses. And even if they haven't witnessed any abuse, they may have witnessed the great job you do as a mother. And a neighbor's testimony may carry significantly more weight than bringing in, your own family to testify to that. Like
Right.
your mom or your dad. Obviously, they're going to say good things about what kind of mom you are, but having a neighbor who may not know you particularly well can be very effective.
Right, right. And we have a question. I have it up on the screen. It comes from Brianne. Hey, Brianne. She asks, can you request a guardian ad litem even if there's no pending court case and not appointed by a judge to oversee a child's care? So, Suzanne, you are a guardian ad litem, so I will let you answer that question.
So in North Carolina, there has to be a pending court case in family court for a judge to appoint a guardian ad litem in the child custody case. Other states may have a mechanism for having a person like a guardian ad litem appointed if there's suspicions of abuse or neglect. But typically, my understanding is across the US, there has to be some pending case, either in child welfare, abuse and neglect court, or in child custody court, where the parents are the ones fighting about custody. So unfortunately, without a pending case, I would say the answer is generally no.
Yes. Okay. And we have a lot of other questions, but I do want to talk a little bit about the role of a guardian ad litem, because you are a guardian ad litem. So what does a guardian ad litem typically do, Suzanne?
So guardian ad litem gets to do a lot of things in the case. We get to investigate the facts of the case. And by that, I mean, so basically, usually a judge appoints a guardian ad litem when the judge feels like they don't have enough information about the child's best interest. So we get to investigate, we get to talk to each of the parents, we get to talk to some other witnesses that the parents each want us to talk to. So it could be a family member, a friend, a neighbor, a coach. We talk with any other professionals involved in the case. So that would be a child's therapist, if there is one. If there's a parenting coordinator, it would be any other, either court-appointed or independent professional. We are required to get copies of educational records, make sure that the child doesn't have an educational need that's going unmet. Particularly because of the conflict during the custody dispute. We can review therapy records, we can talk with the therapist, we can review any records that are in any way relevant to the child. We do, of course, and this is really important to me, as I do GAL work, guardian ad litem work, is to talk with the child, and not just talk with the child once, but to talk with them on at least 2 occasions. I will sometimes do it more, depending on, the specific child. I like to see the child in both environments, in each of the parents' homes. I like to spend a while there so the child gets used to me, because, for them, I'm just a stranger walking into their home. Right. And then if there is an office, maybe at a library, you could also meet the child independently of either home. But it's usually important that you get to see them in both environments. And I think it's really important to ask children, about their experiences, about any concerns they may have, what they'd like to see happen. And it is important, though, that we do have to let the child know that what they tell us isn't confidential, that we may need to write about it in our report. Guardian ad litem writes up a report after doing the investigation and then makes recommendations to the judge as to what they would like to, as to what they think should happen in terms of a parenting plan.
Do you find that judges tend to just adopt whatever the guardian ad litem says in their report?
That has been my experience, and that is what I have heard over the years, that the guardian ad litem tends to have a lot of authority, because the court is relying on the guardian ad litem to gather all of the relevant information. And generally, judges believe that the guardian ad litem has been able to find out a lot more than the judge can in the limited amount of time they have for a court hearing.
Right. What is important information that moms need to be sharing with a GAL if they're appointed?
So I'm going to talk specifically about cases where there has been abuse or concerns about abuse or neglect of the children, or there's been abuse of the parent. I think it's vital that the parent gathers the relevant documentation. And by documentation, I mean it could be criminal charges, 911 calls, criminal convictions, requests for domestic violence protective orders, orders that have been granted. If Child Protective Services records, if CPS is involved, then asking the guardian ad litem to get those. Any documentary information that will give the guardian ad litem more information about how the child has experienced and been impacted by the domestic violence. It could be coercive control. Again, all of the documentation that shows that in some fashion. What I think is really important is not to inundate the guardian ad litem with numerous emails, not to be blowing up their line, but to gather it, to organize it. And if you have counsel, to go through counsel in providing it to the guardian ad litem. Because the last thing you want to do is to come across like, you know, you're obsessed about this issue. You want to show that you're very concerned, but do it in a way that's going to be acceptable to the guardian ad litem.
Okay. And yeah, I was going to ask a follow-up question to that. So how do you communicate with the GAL in a way that doesn't make you come across as if you are an alienating parent or a coaching parent, or put you in a negative light? Like, what do you have some tips for the ladies who are out there and best ways to communicate with their GALs?
I think being as organized as possible in what you give to the guardian ad litem. I think showing up on time for your appointments, whether it's via Zoom or in person, being respectful of their time, and at the same time, obviously, as you're going through this, it's incredibly stressful. Hopefully, you're also getting some support from a therapist or a counselor to help you navigate what's going on, because all of that will help you to present your points more calmly to the guardian ad litem, which will be more persuasive. You know, a lot of guardian ad litems, they're not trauma informed. They haven't been trained in these issues. And so I think many of us in the court system, many players in the court system don't have enough training on these issues, and they misinterpret trauma for some kind of alienation or just being kind of a little out there. So organization, courtesy, and not overwhelming the guardian ad litem with information.
What if you have a GAL who doesn't understand coercive control, who is not trauma informed, and seems to be siding with the abusive parent, and issues a report to the court that's not favorable to the protective parent or the safe parent? Do you have any tips for how to kind of turn things around, either with the relationship that you have with the GAL, or maybe an order has already been issued based on the GAL's report? You know, is there a way to get a new GAL appointed or to turn the custody case around?
A motion to modify would be the way to get back in court on the issue. Obviously, some time would need to have gone by from the time of the first custody order, if it's a permanent one, before you go back into court on trying to change it. But that would be an opportunity to do something different there, assuming that the judge has paid a lot of attention to what the GAL recommended, like you suggested, Tiffany. You know, one strategy, if you have the resources, would be to hire an expert witness on coercive control. It's a good witness, a good expert witness can really educate a judge about coercive control. And also, if they've reviewed the documents in your case, then they may be able to speak to the types of coercive control that they see going on in the case. And that would be without interviewing, you know, the players involved. So I think that would be one way of doing it. In terms of getting a different guardian ad litem assigned, I think that's going to be an uphill battle unless you can show that the case involves domestic violence and child maltreatment and the guardian ad litem doesn't have training in that area.
Okay. So if there's a specific issue that you don't believe that GAL has experience or expertise in, you could maybe move to have someone else appointed who has more experience in that specific area.
Potentially, yes.
Okay, that's a good tip for, and I know a lot of women really struggle with the issue of having a GAL appointed, because GALs can either hurt or help your case.
Absolutely. Absolutely.
Okay. And so I think there's a fear among protective mothers that if I have a GAL, you know, I could potentially lose my children if the report comes out poorly for me.
And that's why I think it's so important to have a GAL with training in these areas, either through experience or through formal training. And if it's a mental health provider, the same thing, because not all mental health providers have that experience.
Right. And we have a question, I think, that resulted from what you last mentioned. This question comes, we're just going to say K. Would an expert witness and coercive control be effective without having a GAL?
Absolutely. And in fact, an expert witness could be more effective if there isn't already a GAL report in place. Because like we said, a GAL report does carry a lot of weight. Obviously, if it's good, that's great. But yes, I think an expert on coercive control in these cases may be the best way of educating the court about what's going on in your particular case.
Right. And just kind of going back to the GAL for a minute, what I tell my clients and my coaching clients, it's very important to know who you are appointing before you agree. So if you have some say or control over that, sometimes judges will just randomly appoint, or they appoint their favorite people and you don't have a say. But if you're consenting or agreeing to an appointment or making a request for an appointment for a guardian ad litem or a parenting coordinator or a custody evaluator or whomever that person is going to be, research, know who these folks are before you agree to their appointment, because they can make a significant impact in your child's life in your custody case, whether that's negative or positive, right? So
totally. 100% agree with that.
Yes. All right. We have another question as well. Would a licensed therapist be considered a witness?
If the therapist isn't treating a member of the family, they could theoretically testify as an expert witness. I don't know how common that is, but a licensed therapist certainly can be qualified as an expert in any number of areas where they have expertise. But there are expert witnesses who focus on specific areas that they testify about in family court cases. I think it's getting more and more common. It's gotten more and more common in the last 10 or 15 years as the various problems in family court have emerged.
Right.
Even more clearly.
Yeah. So there's a difference between a fact witness and an expert witness, right? An expert witness comes in, they don't have to personally know you or your child. They just have to be expert in a particular subject area. And they can come in and talk about the literature, the research, what they know about a particular area, and then potentially make a recommendation to the court. A fact witness is a therapist who has specifically worked with your child. And
Exactly.
They are testifying to facts, right?
Yes.
What this child has said, what the diagnosis has been, what the recommended course of treatment is going to be for this child, that kind of thing. So those two types of witnesses are completely different.
Yes.
This can be one or the other. Okay, so
yes, depending on what they like to do.
And then we have another question. What is the difference between a guardian ad litem and a court evaluator? So I'm going to guess that might mean custody evaluator.
So I know in some, well, actually, could you give a little bit more information about what you mean by a court evaluator? We don't have that term here in North Carolina. I've seen it used, but I'm not clear on what it is.
Okay, yeah, if you could just clarify for us, do you mean custody evaluator when you say court evaluator? And then I do want to talk briefly, I do want to get into your article that you wrote before we run out of time, but do children have constitutional rights in custody cases?
They do not have constitutional rights, but I will tell you something I think that's hopeful in this area. There are 200 countries, almost 200 countries that are members of the UN. They have all approved a convention on the rights of the child, which guarantees the child the right to be heard in all judicial proceedings. So that would include hearings on child custody. Unfortunately, currently the US is the only country that has not ratified this convention. Hopefully it will take place at some point in the future, because there's certainly been a lot more work done, particularly in Australia, Canada, and Europe, on this issue of the child's right to be heard in any kind of judicial proceeding.
That's awesome. That is so awesome. And I do see things changing. There's a lot more education, training, the laws are changing. We have a lot more trauma informed, a lot more women who have been victims of domestic violence, who are becoming lawyers, judges, legislators. And so I do see change happening, which is very, very encouraging. So, women, don't be in despair. I know it's so hard when you're kind of in the midst of things, but things are changing. And so Christine she is from Tennessee, Suzanne. And so she clarified, this is a licensed marriage family therapist, court evaluator, who's meeting with each person in the family. And she said it's supposed to help us make a temporary parenting plan. So I guess it's a person kind of appointed by the court to help with creating a parenting plan. And I know there's a lot of states that require families to create a parenting plan, which the court then adopts as the order. They refuse to have a hearing or whatever else. And so let me go back to the original question, which was, what's the difference between a GAL and a court evaluator?
So a GAL plays a more expansive role. They don't just talk with the family members and the children. They really investigate, or they're supposed to investigate well beyond that. And that's where I would see the main difference. But in terms of each of them carrying significant weight, I think that they're quite similar in that regard. Now, in North Carolina, a guardian ad litem could be an attorney or it could be a mental health provider. Court evaluators probably are more often likely to be mental health providers. But I think the role is certainly similar.
Yeah. So I want to talk about your article that you wrote. And of course, I just lost it. Tell us about the article, the name of your article that you wrote, and why that was important for you to write.
So this article came out of a case where I was representing 12-year-old Jane, and Jane and her mother gave me permission to write it. And to me, it really exemplified how family court may go for years without actually listening to the child's perspective. In Jane's case, the litigation had been going on since the mom was pregnant with Jane. literally, it involved multiple states. It involved multiple child protective service agencies in different states. By the time it got to North Carolina, Jane would have been about 5, and there were allegations of child sexual abuse, which were substantiated, meaning child protective services found that they had happened. And Jane, in the meantime, or for several years after that, for like 8 years after that, Jane was having court-ordered contact with her father, who she had identified as the perpetrator of sexual abuse. There was massive amounts of litigation. The mother was suspected of alienating. And in the prior 2 years, when Jane would have been 9, she was ordered to attend reunification therapy and supervised visitation. And Jane's mother was ordered not to talk to her about her dad and not to talk to her about the legal proceedings. Well, Jane really suffered during the court-ordered visits and the reunification therapy, because a lot of the time she couldn't get the professionals to believe that she was afraid of her father. She didn't want to see him. She was very uncomfortable at supervised visits, but generally there was a suspicion from all the professionals that mom was alienating Jane. Finally, once Jane got appointed her own attorney, which was the Child's Advocate Office, and I represented her in court, we were able to put on evidence so the judge could see this was not about mom alienating. This was, Jane didn't want to see her father and was highly traumatized by seeing him because of her own experiences with him. Mm-hmm. And her therapist, whom she got like about a year before we were appointed, was instrumental in helping to educate the court.
Right. And so we talk about parental alienation syndrome, which has really been debunked by the psychological community, right? It's kind of a junk science, junk theory. However, it has been adopted by the legal profession, unfortunately.
Yes.
So it is something that attorneys and judges, we use that term, alienation. And it has kind of been accepted as a legal.
Yes. It's the only diagnosis attorneys feel qualified to make.
I love that. But alienation is very different from estrangement, right? So estrangement is when a child rejects an abusive parent due to that parent's own abusive behavior. And that many times is actually what we're looking at, right?
I'm glad you brought up that distinction there, Tiffany, because that was very much at the heart of Jane's case. She was estranged from her father because of his conduct. In her case, the court system was treating it like she was being alienated from her father by her mother.
Right.
So estrangement is usually the word means there's a justifiable reason why the child doesn't want to see one parent.
Right. And as we know, abusers have a tendency to reflect, right, their own behavior onto the mother. So if the abuser's doing something, you know, why are you withholding? Why are you talking negatively about me? Why are you, XYZ, fill in the blank? They're going to accuse mom of doing whatever it is that they're doing. And sometimes they're very effective at doing that. Not always, but sometimes they are. And that's where we get into this alienation. So let's talk about reunification therapy. Did Jane have to go through reunification therapy?
She did for about 15 months. She was going to reunification therapy. And then she finally persuaded, or the reunification therapist was persuaded that it wasn't going to be successful. And so she terminated it, or took a pause, I guess is more accurate. We got appointed to represent Jane a couple of years later when the father filed a motion to start reunification therapy again. So The actual reunification therapy and the supervised visits had stopped for about a year, I guess, before we were appointed. It was when the father filed a motion to restart reunification.
So I want to talk about safe versus unsafe therapy approaches in coercive control cases, including reunification therapy.
Mm-hmm. Mm-hmm.
What are your thoughts on, first of all, let's talk about what is reunification therapy?
Well, it's not recognized as a specific form of therapy by the American Psychological or Psychiatric Association. But what happens is it's kind of considered like a specialized form of family therapy as it gets practiced now. And so the goal of reunification therapy is a good goal, or it can be a good goal, and that's to help reestablish a good relationship between a child and a parent that they have been estranged from, or depending on who's looking at the case, they have been alienated from. And so the problem that I have seen, I think at the Child's Advocate, we probably had about at least 20 clients who at some point had been in reunification therapy or were in it at the time we were representing them. The problem was most of them felt like the issues that had occurred that caused them to be estranged, not necessarily abuse, although some were, they were all different, just very poor parenting in some cases, were never really addressed. And it wasn't encouraged to address what had happened in the past, but more to move forward in the future. That sounds really good, but if a child is really upset about really inappropriate parenting, not looking at what happened and helping the parent with those, well, first of all, getting the parent to admit those behaviors and then to address them. If that doesn't happen, then it can be really hard for the child in reunification therapy, and they feel like they have been forced into this situation against their will.
So the abusive parents' rights take priority over the safety of the child.
I would say that happens a lot. Now, I do know some very good reunification therapists, and I think it can be very helpful in cases, for example, where a parent has been out of a child's life for years, and the parent wants to reunite with the child, and the child is open to that. Well, then, that can really be helped with a reunification therapist. But I have seen many more examples of where it was either totally ineffective or was actually damaging to the child to have to go through the reunification process.
Is there an alternative form of therapy that children can engage in with an abusive or, let's say, a neglectful parent that they haven't seen for years that may be better for them psychologically than reunification therapy?
I think there are forms of, from what, I'm not a mental health professional myself, so I'm relying on what I have been told by colleagues of mine who are in this field, that, a more traditional family therapy approach, and I'm not saying having both parties in the same room at the same time, but giving more weight to what the child is reporting and seeing the child's experiences as being more fundamental to the whole process rather than the rights of the parents to have a relationship.
Right. And just like we said earlier in this broadcast, very important to know who the therapist is, whether it's a reunification therapist or a family therapist. What is their background? What is their training before you agree to have this person in your child's life, right? Do they have trauma?
Absolutely.
Training? Do they understand coercive control? Are they going to be easily manipulated by a coercive controller, right? Are they really young and inexperienced?
Right.
Or they have the fortitude to be able to hold their ground and set boundaries with an abusive personality? very, very important, because they also can make a huge difference in your child's life and being an advocate for your child.
Absolutely.
You also might want to find out whether or not they're willing to come testify in court if needed. If they end up filing a CPS report and then you need them to testify and they say, oh no, I don't do that. You signed this document that said you won't involve me, and now they're seeking to fire you or your family. That's not someone that you necessarily want working with your child.
Right.
You need an advocate for your child. Let's talk about, because we're getting really short on time. We've got about 9 minutes left. Let's talk about reunification camps for folks that don't understand what those are.
So reunification camps exist in many states, but probably the ones that have gotten most media attention are ones in New York and in Texas, for sure. And there are other states too. And these are camps that generally last 4 to 5 days. They're called camps. Sometimes they may take place in a hotel. The children may be flown there by specific professionals who are hired for the purpose of bringing the children to this event. The protective parent is generally not involved at this point in the reunification process. So when the children are literally court ordered and often forced against their will to go to these reunification, so-called reunification program, I'll call it. They go through about 3 days of presentations by therapists, videos about showing them how they have been alienated from the other parent. They're very expensive. Oftentimes parents spend, up to $40,000, I've heard, on the actual program itself, as well as the transportation and the accommodation. I have spoken with young women who were in reunification programs like that, what are called camps, and they've had their phones taken away from them at the beginning. They're not allowed to contact anybody while they're there. And many times in the states where they're routinely or often ordered, there's also an order that's required by the reunification program that the child has to be kept from the protective parent for at least, I believe it's at least 90 days afterwards, but oftentimes that 90 days turns into literally years. Caden's law is one of the big very hopeful legislative efforts that's happening now nationally. And that Caden's law has been, it's a federal law, but it's been adopted in about 15 states, I believe, and it prevents the use of these programs, and it prevents various forms of reunification therapy as well when the child is removed from their protective parent. And it requires training in domestic violence, coercive control, child maltreatment for any professionals in the court system that are dealing with these families. So it has a lot of really fantastic provisions in there.
Right. That's awesome. And again, there is change, right, that's happening. But just be aware if a reunification camp is suggested in your particular case, that is something that I think both Suzanne and I would say that's not something you should be agreeing to.
Absolutely.
You should be fighting against if a judge is proposing that, have your lawyer or even yourself speak up against that. Propose something else. Give them an alternative like family therapy. Or a guardian ad litem or a parenting coordinator to help in your case. Do you have any tips for, I know this is a really, really generalized question. Do you have any tips for ways that women can best advocate for the safety of their children in legal cases?
So, one area that I think family court system really struggles to deal with, and protective moms really struggle, is the area if you suspect your child has been sexually abused, who to tell, because oftentimes the reporter, then the person who reports it to the authorities, is regarded as alienating. I would recommend that you first go to a pediatrician and take direction from the pediatrician, the child's pediatrician, as to what to do next. Not talking to the child about the concern of abuse. If the child brings it up to you, not interrogating them. That is an absolute no-no. And obviously, you're going to be so concerned when you have this fear that your natural temptation is going to be to keep asking questions. But just stay calm, accept what the child is telling you, then I would suggest a pediatrician is a good kind of neutral, well-respected professional to give you guidance on what to do next. And always consider that, with younger children, unusual sexual behavior may be just a part of that age. And a pediatrician is also going to be able to help you with that. But, if it turns out that it's well beyond that, getting guidance from somebody like a pediatrician may be a good way to go. The same thing, I think, with physical abuse. It's the emotional abuse that's a little harder to advocate about. Again, going to your pediatrician, it's a concern you have about your child's development. What should I do? And that way, I think it's harder for the other party to say, oh, you're just trying to alienate, because you have, promptly brought the concern to a professional, and not in a way where you're inundating somebody with complaints or making reports to Child Protective Services. Generally, I would avoid making the report yourself to Child Protective Services. It should go through a pediatrician or a teacher or a school counselor or whoever, rather than you being the person to make it.
Right. Yeah, I absolutely agree with Suzanne. I tell, especially sex abuse cases are the most complicated cases that there are, and they have to be handled very delicately. So I absolutely agree with you, Suzanne. The very first point of contact needs to be the pediatrician. And you should absolutely never be making a CPS report as the mother. That's a ticket to being accused of alienation. I do want to, with our few minutes left, talk a little bit more about sex abuse cases, because I should have dived into that before, but Brianne did ask, is it confidential, I guess, reporting to the pediatrician or going to the pediatrician? I don't want her father to know I asked the pediatrician. And you can address that, or I can.
Yeah, you go ahead and address that, Tiffany.
Yeah. Any time you go to the pediatrician's office or the therapist's office, they're documenting everything that happens at that appointment. So everything you've said, everything he said, everything your child has said, or at least they're supposed to be if they're professional. And so they're not necessarily going to call up dad and say, hey, mom came in here and this is what they said. But if he requests the records, he's going to get access to that information. So it can be used against you later on. But generally, my experience is if you think your child is in danger and you're taking proactive measures to protect them, the court's usually not going to hold that against you. But just know that is a risk to you. I don't know if you have anything to add to that, Suzanne.
The only thing I would add is the flip side is if you don't tell somebody like the pediatrician early on, then you're more likely to be accused later on of failing to protect the child. Right. So getting out ahead of it by bringing your legitimate concerns to a pediatrician can help to forestall that accusation of failing to protect. Exactly.
And you also don't want to be accused of, well, you didn't really take this seriously, right? Your child disclosed, or you knew this and you waited all this time. So clearly you didn't really believe this was happening. Right. And so the one thing I will also say, moms out there, is Suzanne and I both have specialized training in trauma and abuse. You don't want to ask children questions that solicit a yes or no response, because children will generally say yes or no. And then what that does, that feeds into your fear. Right. So you'll say, did daddy touch you here? And they will generally, if you say, did daddy touch you here? They have to say yes or no. right?
Mm-hmm.
They'll usually
Right.
say yes. And so now you're like, oh my gosh, this happened, but it didn't necessarily happen that way. You've got to
Right.
ask children open-ended questions that gives them the opportunity to expound. That's so important. But again, like Suzanne said, don't interrogate, don't ask a lot of questions. Just let children tell their story and just listen. That's the most important thing, or you will get accused of coaching.
And generally, I think a pediatrician, it's much better if they're the one doing the questioning, if they, agree to do that, or they may send it, the report to Child Protective Services. But anyone other than you doing the questioning, I would really strongly advise, even though that's easier said than done.
Yes, absolutely. Oh my gosh, there's so many things that we could we could do like a 3-part series on all the things that we could be doing to protect our children. But unfortunately, we have run out of time. We're actually a minute or two over. What we've talked about today is heavy because it's real, right? Children deserve to be heard. Mothers deserve to be believed, and the courts must do better, but they are getting better. So there is hope there. You are not powerless and you are not alone. Suzanne, I want to thank you so much for joining us today. I want to thank you for all that you are doing for children. So thank you for joining me. Hopefully you'll come back again and we can have you on for another Q&A or another segment.
I would love to, Tiffany, and thank you for all your tremendous work for survivors. I'm really thrilled that you're doing this webinar podcast.
Yes, absolutely. And at Live Free Legal, we're building a community of women who are learning to fight back with wisdom, with support, and with faith. If you need ongoing help, practical tools, and a community that actually understands what you're living through, join us inside the Empower Her community. For only $35 a year, you get access to our entire legal library of legal templates, workshops, devotionals, court prep guides, and survivor-centered resources. And we actually created a very specific checklist. It's called the Children's Voice Checklist. It's a prep guide for how best to advocate for your children and keep them safe. And you can get that by joining the Empower Her membership. You can join now by going to livefreelegal.com. Make sure to hit subscribe before you go. Drop a comment with your biggest takeaway and share this video with someone who needs a lifeline today. We are reminding you that you and your child are worth fighting for, and you do not have to do this alone. Again, thank you, Suzanne, and we will see you next time. We do a live Q&A every Thursday, the third Thursday of every month at noon. So thank
you.
All right. Have a great day, everybody.